we'll get started so that you can all go and enjoy your weekend or keep studying for contract law, as the case may be. My name's Bridget, and I should start by stating the obvious. I'm not a lecturer, so if anything that I say conflicts with anything that your lecturers have said, please ignore me. Your lecturers mark your papers and they're much more qualified to teach contract law than I am. I should also mention I have cited cases for principles in this PowerPoint based on what we did in Francis Dawson's stream last year. I think last year and this year there are some differences between the cases that you use in the stream. So if I talk about a principle and that sounds familiar but the case I've cited doesn't at all, use the cases that you've used, because if you use my cases, your marker might think you've just picked someone else's notes up, which of course none of us ever do. We all do our own. So the plan is an overview of the concepts that you've covered so far and a run-through of the first 2014 test. The way that I've kind of arranged the PowerPoint is I've divided it up into all of your topics, which we'll go through in a moment. And with each topic, I've tried to start with kind of the basic kind of fundamental proposition associated with that topic, which I think should be the starting point of your answer if one of these issues comes up. And then from there, we'll move into the possible sub-issues that may or may not come up, depending on the facts that you get. So what you've studied so far, hopefully all of these things sound very familiar to you. You've studied the ingredients of a valid, legally enforceable contract. So they are, of course, objective consensus, an intention to assume legal liability, offer, acceptance, finality and completeness, and everyone's favourite, consideration. So I'll start with objective consensus. So the basic proposition here, and I'll put this PowerPoint up on PowerPoint, so don't worry about frantically writing things down. The basic proposition is that both parties must agree to the same terms in the same sense in order for there to be a valid contract. And you can cite Smith and Hughes for that, it's a pretty classic case. But of course, whether or not the parties have agreed to the same terms in the same sense is ascertained objectively. As such, a promise is construed in the way that it would appear to a reasonable counterparty. What this means for practical purposes is that adequate grounds for mistakenness must be proved in order for a party to exit a contract on the grounds that there was no meeting of the minds. The thing with objectivity is I don't think I've ever actually seen a test question, that is only about this kind of issue, because the reality is mistake, which is what this sort of generally applies to, is covered by legislation that you'll cover later in the course. But I think what we really want to take away from this section of the course is basically that contract is an objective discipline. If we allowed people to rely on their subjective intentions, they could objectively agree with someone and someone could rely on that promise, and then I could turn around and say, oh, that's not actually what I meant, even though what I manifested was clearly what was agreed to. So that's kind of the key takeaway there. But you might get a question on it, in which case following this sort of structure probably would serve you well. So the next issue is, of course, intention to assume legal liability. And the starting point is probably, it seems quite obvious, but I think it is still worth stating because you want to be really systematic, is that a contract requires an intentional assumption of legal liability. So an agreement that appears in most other respects to have been made will not give rise to an enforceable contract when the parties don't intend to create legal relations. And like we've just discussed, whether or not they intend to create legal relations will be assessed objectively, because contract is an objective discipline. So, that's your starting point. When might the party's intention then to assume legal obligations be questionable? Have you guys done Balfour and Balfour? That's quite a classic. Yeah. So all you'd probably want to take from that is that when the parties are husband and wife living in amity, their intention to be able to enforce their sort of promises to each other legally will be quite questionable, simply because the courts sort of infer that when spouses or even families make promises to each other, even if there's consideration, the idea is that those promises are kind of enforced on the good faith of family members, not of contract law. And like I've said, the same applies to family members in a very similar way. Other situations where the party's intention to assume legal relations might be questionable or doubtful is when the parties have entered into negotiations and may have even agreed on all of the terms, but a formal contract is yet to be created or finalised. And so examples are the parties create an agreement that says subject to a formal contract. So in that situation, there's no formal contract yet, so there's no intention to assume legal relations in respect of those promises. Another example is if the contract has not yet been executed by both parties, and that's Concord Enterprises. And I think that's sort of common sense. You know, people don't intend to be bound until they execute the documents. But all of these are just assumptions, and they can be displaced if there are facts that demonstrate that there is a manifest intention to be bound. And that's Jones and Patervatten that you could cite there. The final situation in which an intention to assume legal liability might be absent is when the parties have specifically stated in the agreement that it is not a formal agreement, subject to the purview of the courts. If those statements are sufficiently clear, the courts will uphold them. You could call it an assumption, but this one really isn't rebuttable. Because in these situations, it's almost impossible to say that there was a manifest intention to be bound, because the manifest intention is clearly not to be bound. They've said that in the agreement. Finally, one situation that might point towards an intention to be bound that you could use is the fact that the parties are commercial parties, creating like a commercial arrangement. In those situations, you know, those people are spending a lot of money. We expect them to want their contracts to be legally binding. But again, that's an assumption that can be displaced by sufficiently clear statements or behaviour. So the first two topics are sort of smaller. From this point on, you get into some of the bigger substantive topics. I would be very surprised if in your test there wasn't a question involving offer and often acceptance as well. And so the starting point, and that's a sort of question, and I think the way in which you probably want to start your answer, is that an enforceable contract requires a valid offer and acceptance. That's your basic point. Ultimately, whether or not an offer has been made depends on the intention of the offeror, and that's obviously always assessed objectively. So now we're kind of getting into the possible sub-issues that you might get. So you've realised that you've got a question on offer. You probably want to start here. And then you've got to work out, okay, which of the sort of sub-issues or specific issues are concerned here. So one of the ones which we've covered is, I think, an invitation to treat. So a distinction must be made between an invitation to treat and an actual offer. They're not the same. And that distinction turns on the objective intention of the parties. You learn in Boots Chemists that the display of goods on shelves with prices attached is not an offer, but an invitation to treat. That's something I think it will be very clear on the facts if you're being invited to state that, because you have a situation with things on shelves. There is also a tendency to regard advertisements as invitations to treat rather than offers. The offer, in this situation, they conceptualise it as the offer actually occurs when the customer offers to make the purchase, which is like the equivalent of going to the counter with your stuff. So it's quite consistent with Boots Chemists. But it's totally possible for an advertiser to make a clear offer. And you get this from the Carbolic Smokeball case. So in that situation, I think what was really definitive was that the poster actually said, excuse me, the poster said, we've set aside money to make good on this offer. And so that, I think, sort of swayed the court in the direction that this was intended to be a legally binding offer. So you learn from Boulder Consolidated that exploring areas of compromise is in the nature of invitation to treat and is not itself an offer or a counter offer, as the case may be. One of the further potential areas that might arise under offer is whether the offer is terminated or lapsed before it's been accepted. And so a situation where an offer is terminated, for example, is when the other party makes a counter offer. That counter offer is regarded as a rejection of the original offer, And so that initial offer is no longer available for acceptance. And I've used this idea of the battle of forms from Butler Machine because I think it kind of explains what you might be asked to do in a question where you have possibly like a series of correspondence between parties. And you've got to go through and identify the offers and counter offers and work out where there is actually a union of an offer and acceptance of the same terms. So that's all I mean by that battle of forms. I don't know if you necessarily need to say that battle of forms quote, but I just think it kind of captures the sort of exercise that you're undertaking. So, to work out whether a counter offer has been made, you need to know what constitutes a counter offer. Acceptance of an offer must exactly correspond with the offer. So if you import any new terms, that's a counter offer, and then that then requires acceptance from the other side. A request for more information or an inquiry as to whether the offeror might alter their terms is not construed as a counter offer. So you've got to have something quite specific by way of counter offer or rejection. Another situation which an offer might no longer be valid for acceptance is when the offer is lapsed by virtue of fundamentally changed circumstances. Whether this has happened depends on, excuse me guys, whether the promisor objectively intended to be bound under the altered circumstances. But what you've got to remember when you're sort of working in this area is that the offeror is master of the offer. They can attach any conditions to the offer that they see fit. You know, they have total control. So they're perfectly able to make their offer conditional on certain circumstances remaining the same. And the courts won't necessarily save them if they fail to do so. So what this means for you guys is that you're going to want to see some seriously fundamentally changed circumstances before you're going to say that the offer's elapsed on the basis of that change. Because of that policy, you know, the offeror is master of the offer. And you can say that in your answer, that that's sort of the policy that's operating here. So an offer can also expire. An offer which expressly states that it will lapse on a certain day can't be accepted after that day. Where no time is specified, an offer is open for acceptance for a reasonable period of time. What is reasonable is determined objectively and depends on the facts, so that's quite a fact-sensitive question. If the parties were maybe their agreement involved the purchase of some shares that had just hit peak value and the market could change at any second, the reasonable period in which the offer is going to be accepted or can be accepted is probably quite limited. But in other situations, there's no particular urgency. I think you could probably safely say that a reasonable time will be a bit more lengthy. So it depends on the facts, and you might have to analyse that. Offers can also be revoked. There is some ambiguity in the case law as to what you need to do to revoke an offer. Leon van Tienhoven says that in order to withdraw the offer, the offeror must communicate the withdrawal to the offeree. But King and Homer says that knowledge on the part of the offeree that the offeror has acted contrary to the offer is actually sufficient to revoke the offer. Often, I think it can be confusing when you have an ambiguity to work out how you actually should answer a question where, you know, this ambiguous part of the law probably applies. What I would do is set out both positions and apply them both, and argue in the alternative in respect of the second one. And that shows that you understand both positions and that it's not quite clear which is going to apply. So that brings us to acceptance. Like I said, a question that involves offer will very often also involve acceptance. I actually quite like to split my answer up into an analysis of offer and acceptance just because I think it makes things easier and a little bit more efficient. So your starting point is the same as with offer. In order to create contractual obligations, you have to have offer and acceptance. It's the union of the two that creates the obligation. Unilateral contracts are a bit of a special case. So hopefully you guys know that a unilateral contract is a promise in return for a requested act, whereas a bilateral contract is a promise in return for a promise. So if a unilateral contract is a promise in return for a requested act, you actually accept by doing the requested act. The acceptance occurs at that moment. But it's not quite that straightforward. The offeree has to perform the requested act on the faith of the offer. So if someone's put an offer out there saying, I'll pay you $100 to do this, and you have no idea of that offer and you go and do it anyway, you haven't really accepted the offer. You didn't even know about it. So you have to perform the requested act on the faith of the offer. So if a person does know of the offer and performs the requested act, it's inferred that they intended to accept the offer. This presumption can be negated if the offeree admits that they didn't intend to accept the offer, which I think happened in the Crown and Clark case. The person trying to claim the money there just shot themselves in the foot completely. So if in your facts the person does that, then you can apply Crown and Clark and say they've admitted that they didn't actually intend to accept the offer. In cases other than unilateral contracts, what constitutes acceptance depends on the intention of the offeror. If the offeror is silent as to the mode of acceptance, the presumption is that the offer will be accepted in the usual way. However, if the offeror stipulates the method of acceptance, you can only accept by that specified method. The offeror is the master of the offer. If they make conditions on the offer, you have to fulfill them in order to accept. So, post will be an acceptable means of acceptance if it can be objectively inferred from the circumstances that the offeror contemplated acceptance by post. A massive clue in this area is, how was the offer made? So if someone sends you an offer by post, you should be able to accept by post. I think that's quite reasonable, unless they've stated you must accept by ringing me. But if they haven't stated anything, I think it's quite reasonable to infer that you can accept the same way that you've been offered. So that's a good thing to look for in your question, how was the offer made? And we'll cover that when we do the 2014 test. If acceptance by post is authorised, the acceptance occurs when the letter is posted, and that's just known as the mailbox rule. However, when a contract is made in person or by instantaneous communication, which most will be in modern times, the contract is only complete when the offeree or the offeror is communicated that acceptance. So basically, if you're talking on the phone, it's instantaneous. So you accept, they hear you, contract created. The second to last area is, I think you guys call it finality and completeness. My tutor actually used to call it certainty and completeness, and I found that a little bit easier to understand. The idea here is just basically that the essence of contract is consensus, and in order for there to be consensus, the parties must have agreed on all of the essential terms, or at least agreed on an objective means of sufficient certainty by which those terms can be determined. So that's kind of the basic idea in this area. So if the true intention of the parties was not to enter into a binding agreement if and until certain terms were settled, no contract can come into existence in absence of the further agreement. For practical purposes, this means you can't have an enforceable agreement to agree. But the courts don't like this reputation of destroyers of bargains. If people intend to create legal relations and then come to the court and say, we want you to enforce these, the court will try hard if it can. What they'll often look for is a way to basically construe the agreement fairly and broadly and apply terms in a manner that makes the agreement work. Basically, they'll look for some kind of objective criteria, and they don't just pull that out of nowhere. They're looking at what the parties will have intended, by which they can determine whether the uncertain term has been fulfilled. They'll kind of imply a bit more substantive content into the term. So, for example, if you have parties who have made a contract to negotiate, and that's all they've said, and then one party comes to court and says that they didn't negotiate, and the other party said, yes, they did, the court's kind of got to construe what is meant by negotiate. So perhaps that'll involve saying, well, it seems, based on the way parties have conducted themselves objectively, that negotiating involved attending these 3 meetings, bringing their legal advisors, coming with an open mind and negotiating in good faith, or something like that. they'll imply kind of more content into the uncertain or incomplete term in order to be able to enforce the agreement. We actually never got assessed on this, and I'll put my notes up on Facebook with the PowerPoint, and you'll see I've got quite long notes on this, I realised when I read them, which probably shows I didn't fully understand what it was all about. But by all means have a look at those if you want more information, because there's quite a lot of sub-issues here around process contracts and contracts to negotiate that are probably worth looking into. The final area is consideration, which is probably the biggest of the areas that you cover. If you get a question on consideration, and this is kind of like offer and acceptance, like I say, it's one of the biggest areas. I'd be surprised if you didn't get asked about it. So really where you want to start is you want to come up with some sort of sentence that shows you know that you have to have consideration in order to enforce an agreement. And you have to describe what consideration is, so show that you know what it means. So I picked kind of the description out of Bolt and Madden, which is a little bit wordy, but consideration is quite a elusive concept. It's quite hard to explain, so I just found it easier just to deploy this this little phrase, which is basically consideration, as is required to constitute a contract, will occur when the plaintiff agrees to do something on the terms that the defendant agrees to do something else if what the plaintiff has agreed to do is either for the benefit of the defendant or the detriment of the plaintiff. And all that actually means or comes down to is that there's some kind of bargain. There's an exchange happening. The parties are giving each other value. Yeah. So, what constitutes valid consideration? Past consideration doesn't. So, where the act precedes the promise. So, that's a situation where you've maybe performed part of an obligation. I suppose, did you guys do the Roscola and Thomas case with the horse? Yeah, so that's like the classic case. I think he sold, I can't remember the exact what was wrong with the horse, but basically one party sold another party a horse, transaction was all completed, person paid and took the horse home, and then came back and asked the seller of the horse something about the quality of the horse, and the seller said, oh yeah, the horse is fine, and it wasn't. And the person who purchased the horse, probably quite understandably, was gutted and came to the court and said, they promised me this horse was fine and it wasn't. But this was past consideration. They'd already handed over the money and agreed to buy the horse. So they can't, unfortunately, then seek to enforce the subsequent promise because they didn't give any more consideration for that promise. However, if a promise is made after an act which was requested, and a reward was expected, that promise can be binding. So at first blush, these kind of situations often look like past consideration. But if the act was actually requested, that renders the act contractual, and any later promise as to the quantum of the reward simply represents the fixing of the price. And good examples of that are Lampley and Brathwaite and Re Casey's patents. This first point is what people often call the peppercorn rule. I don't know if you guys have heard that phrase. Yeah. Basically, the courts don't save people from bad bargains. So if you've had some consideration, but it's totally inadequate compared to what you've given, there's still consideration. It doesn't matter that you got a really bad deal. One example of that is the Otahuhu Borough case, where land was actually gifted to the defendants, and it said that in the contract, this is a gift. But one of the terms was that the land be a public recreation area named after the plaintiff. And the courts regarded that the fact that you're going to get a park named after you is kind of value in some way, and so that was enough to be consideration. And there's the Nestle company case as well, where the chocolate wrappers, which don't have any value, were nonetheless consideration. Compromises. This can be a little bit confusing, but basically the proposition is that forbearance to sue, which is like promising you're not going to enforce your legal rights against someone, is valuable consideration, provided that the plaintiff has a bona fide and honest belief in their claim, and the claim is a real claim, and a real claim is one that is bona fide believed in and not vexatious or frivolous. Honest belief, this is a very rare situation in contract we are concerned with subjective intention. Honest belief is subjective, purely for the reason if you don't actually believe you have a claim and then you try and elicit a bargain out of someone by saying, oh, I've got this claim against you, but I won't enforce it, you're actually acting fraudulently. So that's not allowed. So honest belief is subjective in this context. Existing legal duty, another possible sub-issue. So performance of an existing legal duty to a third party may well constitute consideration if it is a benefit to the promisor. So there's a different treatment here of situations where you're promising to perform your existing legal duty to a third party or promising to perform your existing legal duty to the person just between the other party to your legal agreement. In the second situation, in order for there to be a binding variation of an existing agreement between two parties, there needs to be some promise to do more than was initially required. There's no consideration if you agree with your counterparty to do what you're already obliged to do, because you haven't given any value. You already had to do something anyway. So promising to do that isn't giving any additional consideration. You have to introduce some fresh consideration. So, for example, I think you guys look a little bit at the context of debts. So a promise to pay less than the sum that is owing cannot be consideration because it's simply a promise to perform part of an existing legal duty. If you're going to settle a debt for less than face value, you've got to introduce some fresh consideration, and the adequacy of that consideration is for the counterparty to assess, not the court. So sometimes someone will be able to settle a debt for less than face value based on the other party's agreement to do so. Because, for example, they agreed to pay in cash other than cheque, and that's material on the facts, or maybe they agreed to pay sooner. So it can be quite subtle, the new consideration, but it's consideration nonetheless. You might also, in this situation, find help from Section 92 of the Judicature Act, which states that if the creditor acknowledges in writing that payment of some debt in satisfaction of the whole is acceptable, then that acceptance is binding, irrespective of the above rules. So it's kind of a statutory reversal of Folks and Beer. So make sure you take notice on the facts of whether the creditor has agreed to accept less money in writing, or they've just orally stated that, because that would be quite important. There is some controversy about whether the additional benefit that you provide, so the fresh consideration, has to be a benefit at law, or whether a practical benefit is enough. So a benefit at law is when you sort of acquire an additional legal right. A practical benefit is you might not necessarily achieve or obtain an additional legal right, but you get some sort of practical benefit. And a good example of that, I think, is Williams and Roffey Brothers is actually the case that says a practical benefit is enough. And there, the court upheld an employee's promise to pay a contractor more to do what he was already obliged to do, on the basis that they obtained a practical benefit and that it ensured the contractor performed their obligations on time. How many of you guys are in Francis's stream? Have you covered this Williams and Roffey Brothers? Did Francis say anything about what he thinks of this case?
He liked us with that.
Yeah. I don't think he's a fan, because I think, like we say, the idea of a practical benefit kind of undermines the need for any fresh consideration, doesn't it? You could almost always find a practical benefit. And when you combine this idea of a practical benefit with the idea that consideration doesn't have to be adequate, it just has to be there, you could find some sort of consideration that is totally puny and enforce the promise on that basis, which is quite problematic, I think. That's probably a little bit more detail than you need to know. And if you like Williams and Roffey Brothers, and it's actually been applied by the New Zealand Court of Appeal, by all means say that. But I don't think it ever hurts to suck up to your lecturer, so if you're in Francis' stream, maybe say that it's questionable authority or something like that. Final sub-issue is moral consideration. If you do something for someone else, maybe even to your own personal detriment, that they haven't requested, but it's really helped them out, And so they subsequently promise you, they'll pay you or do something. In a moral sense, maybe that person should keep their promise, but in the eyes of the law, this is just past consideration. So, I mean, you did something without being asked to, and then got a promise for it after. It's just past consideration. It doesn't support a binding contract, and that's the orthodox position. I think you guys might, though, cover the case of Webb and McGowan, in which past consideration, they don't worry about the past consideration issue. They uphold a promise, despite the fact that it's pretty much past consideration, because the circumstances are quite morally compelling. But this is a New Zealand decision, and it's also a massive outlier in this area of the law. So worth mentioning, because you've been given it, but probably make some sort of statement to the effect that, don't mislead your client and say, oh, there's this great authority that you can use. It's probably not great authority, but it's out there. It's worth mentioning. So what I thought we would do for the last half an hour, that's good that we've got plenty of time. Or maybe first, are there any questions? So what I thought we would do is the 2014 test, which I think, have you guys covered this in Marcus's class? Yeah. Okay, well I won't be offended if you want to leave. But if you haven't done this, this is a really useful test to go through. Basically because I think it's reasonably similar in format to the test that you'll get. And also with these short, you get really short fact scenarios, look, I can fit it on one slide quite easily. And sometimes you think oh, there's not much to talk about here, but they load these things with stuff you can talk about. Every sentence is quite loaded. So I think it is well worth going through and just going through the exercise and picking out the various issues. So I'll give you guys some time to maybe read through that, and then we'll go through the way I answered it. Yeah. Sorry. No, that's okay. Shouldn't take long. Yeah, not very long, as you can see. So, we're asked to advise A as to his contractual obligations, if any, to B. As this is law, we always state the issue reasonably close to the beginning of our answer. And at a very high level, the issue is whether we have a union of offer and acceptance such that a binding contract was formed. And we know that the basic principle is that there must be a valid offer that endures up until the moment of acceptance in order for the contract to be binding. And like I said before, I like to split my answer into offer and acceptance. So I started with offer, and by all means use headings too. Don't intimidate your marker with pages and pages of uninterrupted writing. Use headings, space things out. Just make it nice and easy to read. Put your marker in a good mood. So offer. So A's clearly made an unequivocal statement of his willingness to be bound when he offered to sell his car to B for $10,000. So the issue, or sub-issue you could say, is then whether A's attempt to withdraw that offer is operative. It's established in Dickinson and Dodds that an offer can be revoked any time before it is accepted, even if the offer was specified as remaining open for a certain period of time. So, A's not harmed by that. He can withdraw the offer. But in order to withdraw the offer, you need to bring, according to Byrne and Leon van Tijnhoven, you have to communicate that withdrawal to the offeree, which is questionable here because B hasn't received this letter yet. The alternative view is that knowledge on the part of the offeree that the offeror has acted contrary to the offer is sufficient to revoke an offer. That's not really raised here because B doesn't have any knowledge of that kind. So the revocation of the offer wasn't communicated to B, and B wasn't aware that A had acted contrary to the offer, so the offer is still live. So now we turn to the question of whether or not it was validly accepted. As we've discussed, what constitutes acceptance depends on the intention of the offeror. A hasn't specified here. So we've got to do a little bit of factual analysis and infer what's acceptable. And it's quite reasonable to infer, I think, that post was an okay means of accepting. And like I said before, here A's made the offer by post. So you can infer from that you can accept by post. And we know from the mailbox rule that acceptance occurred the moment that the letter was posted, So the conclusion is A is obliged to sell his car to B for $10,000. Does anyone have any questions? Question 2. I'll give you some time to read that as well. Is that enough time? So the question that you are asked to answer is whether B is entitled to recover her 10 grand from A in contract law. So the issue is whether there is valid consideration for A's promise to B to pay $10,000. In order for the promise to be enforceable, some consideration must have been given, and you want to define consideration. We know that past consideration is not sufficient. Here, the promise was given after the act, so prima facie, this is past consideration and there's no contract. However, like we've said, if a promise is made after an act which was requested, and the subsequent promise might be regarded, then the subsequent promise might be regarded as merely fixing the quantum. A did say to B, save me at all costs, which you could interpret as a request, and then the subsequent promise to pay $10,000 could be regarded as fixing the quantum. That's an argument that people did make, and that I made as well. But I also said people say all kind of things when they're falling into quicksand or in life-threatening circumstances. And so those sort of statements, I said, probably won't be regarded as sufficient to ground contractual relations. The alternative issue that you could raise in addition to what we've just discussed is the one of moral consideration, in which case you could apply Webb and McGowan. But I did note in my answer that Webb and McGowan was dubious authority to start with. Also, even if it were perhaps regarded as good authority, the facts there were extremely compelling. I think the recipient of the promise, had actually hurt himself quite seriously. B just grabbed a rope and helped A out. She shouldn't really be able to get 10 grand for that, and I think probably as a society we just expect people to save other people's lives as they can. Shouldn't have to get paid $10,000. But that's a common sense point rather than a contractual law one. So I concluded that B could not enforce A's promise. But if you differed in your conclusion, that would be absolutely fine, and that goes to the same question. As long as you've gone through the analysis, by all means you can come to a different conclusion than the one that I have. And finally, question 3. So, you have to advise A as to whether B is in breach of his contract to sell. I really hope they don't do A and B on you again, especially in all 3 questions. It's so easy to mix them up. If they do, just proofread your answer and check that you've got your A's and B's around the right way. It's so cruel. They could have done like Shirley and Tom or something way more easier to distinguish. But no, they just did A and B. So anyway, we're advising A. So the issue is another consideration question. Is whether sufficient consideration was given in respect of B's promise to accept $10,000 instead of $15,000 per the original agreement. And we know from Stilk and Myrick that in order for there to be a variation of an existing agreement between 2 parties, there needs to be some fresh consideration. And the orthodox position is that consideration has to be a legal benefit. So applying that, A hasn't offered any new legal benefit. So there's no valid consideration. However, Williams and Roffey brothers suggest that a practical benefit is enough. So it's worth applying that and saying, maybe you could argue that B obtains a practical benefit and that A is otherwise unable to pay for the car at all. But again, if you're in Francis' stream, I'd preface that with a statement that Williams and Roffey brothers sucks, but in more legalistic terms. Also, we've got Section 92 of the Judicature Act. So if B's initial acceptance of $10,000 was in writing, she'll be bound by that per Section 92. But the facts don't actually say whether there was writing or whether it was just oral. So we can't make a final determination there. So I concluded that B was not in breach of his contract. I'd now just like to maybe offer some really general advice. One piece of advice is, I think, or in my experience, this is like a perfectly acceptable way to cite a principal semicolon case. And that's really quick, sharp, and efficient. I use that in almost every subject and I've never been told not to. So I think that's perfectly legitimate. The other thing I think can be tricky is just working out how to start. Like, you get these questions, and you're all very capable, I'm sure you could recognise the various issues. Sometimes it's hard to know how to begin your answer. This is something that I found really useful in contract. I am asked to advise X, whatever the name is, as to whether their agreement with whatever the other person's name is legally enforceable. For the reasons given below, I do or do not consider the agreement to be enforceable. And that is literally all you would need by way of introduction. And then, like you've seen in the way that I've gone through those other questions, I'll kind of state an overall issue at a really high level. So is there offer and acceptance? State the relevant law and apply it. Most likely need to get into some of the sort of sub-issues that we've covered. And then finally, briefly reiterate your conclusion, which is basically just reword the question to include your answer. Really sharp, really clear. Like I said before, use headings, use paragraphs. And I have huge writing, and I think my longest paragraph was like half a page. Just really split things up. It's not like an arts essay. I'm an art student. I found it hard to abandon this too, but you don't have to write nice paragraphs. It's not a paragraph structure. It's a legal analysis. So just space it right out. Another piece of advice is don't information dump. So sometimes you get these factual scenarios and you're pretty sure there's a few principles that apply, yep, but then you think, oh, maybe this one also applies, I'll just put it just in case. I really advise you not to do that. Spend the time that you would have spent writing that extra amount, thinking really hard about whether or not that extra issue applies. I think it really just signals to your marker if you just throw down a whole lot of stuff that you don't actually know what you're talking about. And like, we all have open book tests, right? So you get your points for application, and a huge part of that application is just working out what you're supposed to be applying. So don't just apply everything you can think of. Be specific and work out what you really think is raised by the facts. Does anyone have any questions? That's good or bad, but I haven't baffled you all. Thank you to AOLSS and Russell McVeigh. Good luck with your test. Enjoy it.
Just so good. Oh.
It's good.